are so happy to have Judge Wismer with us today. Just so you know, a couple of years ago, he was running for re-election for Arrowhead Justice of the Peace, so here in Peoria. And our interview work group, our candidate interview work group, interviewed him, and they found him so fascinating, so interesting. They wanted us to make sure that we invited him back. And this was the first opportunity where our schedule and his schedule actually came together so we could have an event like this. So please welcome Judge Wismer.
Liz, thank you.
Thank you very much.
Well, I appreciate the invitation to join you here today. I'm not sure that I deserve the accolade of fantastic, but we'll work off of that. So thank you.
That'd be great. So to start with, why don't you tell us a little about yourself and how you came to be a Justice of the Peace?
Sure. Let me just set that there. Okay. Well, of course, my name is Craig Wismer, and just a bit about me to set the stage as we move into the questions, just so you get to know me a little bit better. I'm not quite a lifelong resident of Arizona, but I'm come pretty darn close. I've lived here in the Valley, in the West Valley, really, for probably about 48 years, but for a little bit of time that was spent overseas in Indonesia. Grew up down in Glendale, down around Apollo High School, and then spent some time overseas, came back, lived in Glendale again. And my family and I have lived in Peoria now for about the past 25 years. We're out at 91st Avenue in Thunderbird. I attended and graduated from Brophy, went to Arizona State University's main campus, and I actually attended classes there and at West Campus, and received a degree in political science. When I was in my final year of college, there was an opportunity for me to apply for, and I did, a political internship with then Congressman John Kyle when he was representing the 4th Congressional District in Arizona. I served a one-year internship with him, and then with about 6 months left in college, I accepted employment with Congressman Jay Rhodes out of his office in Mesa. When I graduated, fortunately, it just so happened that there was a member of then Congressman Kyle's staff who was retiring, and he extended to me an offer of employment, which I readily accepted. And so I remained on his personal staff, both in the House of Representatives and in the United States Senate, through his retirement in 2012, serving in various capacities, a project director and so an issue specialist on certain types of issues and whatnot. But really more to your point, then it's a segue into what happened. And that is Senator Kyle retired from office in 2012. And of course, I'm doing a job search. And it just so happened in 2012, in July, the Arizona Supreme Court removed from the bench the then Arrowhead Justice of the Peace for some documented transgressions and violations of the Arizona Code of Judicial Conduct. When they removed him from office, they need to fill a vacancy, but because of the timing of the removal, there wasn't an opportunity to run a traditional campaign where you actually go out and circulate nominating petitions to have your name actually placed on the ballot for a vote. It had to be done as an all write-in vote or all write-in ballot. So it was left to the candidates to actually go door to door and convince folks to actually write your name into the ballot. And I was successful, and I filled out the remainder of that individual's term for 2 years. I ran for re-election for a full 4-year term in 2014. And then, as was mentioned, I did run for re-election in 2018. And frankly, in no small part to the support that I received, the endorsement from WEMAR, which I understand at the time was their first foray into supporting a judicial candidate. And this is an elected office, supporting a judicial candidate that was running. And so, again, due in no small part to the support that I received, I was successful in 2018, and I'll be serving another 4-year term and would stand for re-election in 2022. But that's a little bit about how I came to serve in the capacity that I am right now, but I know we wanted to talk about more than politics. So,
so let's describe what the justice courts are, what your district, your Arrowhead Justice Court, what is that district? What are the other districts that we might see?
Sure. There are, by my last count, first of all, the job of the Justice of the Peace is actually written into the Arizona Constitution as far as the qualifications to serve. And it is, again, an elected office. There's either 91 or 92 justices of the peace in Arizona. I confess I forget the exact number, but their precinct boundaries are identified by certain parts of town. And in the Arrowhead Justice Court, the precinct boundaries include all of Sun City, a portion of northern Glendale, basically Arrowhead Ranch North, and then a good portion of the city of Peoria, basically the halfway line on north. Think of the boundaries of no further south than Northern Avenue, 115th Avenue to the west. To the east, it does zigzag around 59th Avenue, and then it goes all the way up to the 303 in kind of a pyramid. But those are the geographical boundaries.
Okay. And what type of cases do you see?
Justice courts are known as a limited jurisdiction court. The general jurisdiction courts are superior court. The justice courts in Arizona and municipal courts are known as limited jurisdiction courts. Our jurisdiction is limited in some way, shape, or form because of either the type of criminal cases or types of criminal charges rather that we can adjudicate and that could be filed into our courts, or for civil cases, the amount of money that somebody is wanting the court to award, and there is a monetary cap on that. But the types of cases that we could see would involve civil lawsuits, civil disputes with a monetary cap of no more than $10,000. We do have a small claims division where the cap is capped at $3,500. We also handle eviction matters. We handle orders of protection, and we also handle civil traffic matters, civil traffic cases. We'll also handle misdemeanor criminal charges, and this could be anything from misdemeanor DUI to assault, theft, shoplifting, criminal speeding, reckless driving. And in addition, I also serve as a juvenile hearing officer.
Okay. So in the case of a civil case, is it the monetary denomination that determines whether it comes to your court or goes to superior court, or how is that determined?
Indeed. When the complaint is originally filed, if it is for an amount under $3,500, the plaintiff, the person filing the complaint, can choose whether they want to file it in the small claims division of a justice court or if they want to take it right into the civil division. That's going to be their call. Part of what they need to understand, though, is that if it is filed in the civil division and it stays in the civil division because nobody asks for it to be transferred to the small claims division, if that's where it's filed and it stays in the small claims division because nobody asks for it to be transferred to the civil division, then it may very well go to a small claims hearing. The end result is binding on both parties is the decision of that small claims hearing officer. In the small claims division, a case cannot be appealed. You're willing to accept the decision of the hearing officer. If a case is initiated in the small claims division, somebody doesn't want it to stay there, either the plaintiff decides to take it out or the defendant decides to file an answer to the case but doesn't want it to stay in small claims, they can request that it be transferred to the civil division, and then it will be handled there. The civil division is indeed capped at $10,000. If somebody wants to file a claim for a monetary judgment for $1 million, I don't have jurisdiction over it, and we tell them you can't file in a justice court, it has to go to superior court. If the original claim, for example, is for $9,000, well, yes, we have jurisdiction over it. If the defendant chooses to file an answer and they file a counterclaim for $20,000, again, we no longer have jurisdiction on it, and so the matter would have to be transferred to superior court if it's still going to be heard.
So you may not be familiar with the structure of the courts in Arizona, or you may have pockets of knowledge and pockets where you just aren't sure. I will have on the Arizona Supreme Court site, they have a whole layout of the court system in Arizona. So who goes to what and where they stand in that hierarchy. So I will have that up on a blog post on weservegad.org tomorrow morning so that you can sort of get your grounding on what courts are where and how they interact in the state. So that might help you visualize this a little bit. So what type
and Liz, if I could interrupt for just a moment.
Sure.
Just to dovetail on something that you said, or rather to expand on it. There also is another resource, even for the justice courts. It's justicecourts.maricopa.gov, G-O-V. It is a website run by the Maricopa County Justice Courts. Does it have forms on there that if you want to, you're not really sure how to fill out a complaint or how to file an answer? Does it have those forms on there that will walk you through the process? It sure does. If you're a defendant, does it have a notice to defendant on there that tells you if a lawsuit's been filed against you, what you can do and what your timeframes are? It sure does. If you want to file an eviction case, either you are filing to evict somebody or you're defending on it and you're not sure what the timeframes are or what you can do and when you can do it. Does it have the information on there? It sure does. It's another resource, including if you needed to find out where your case is at. I mean, you can, of course, always call the clerks. But if you needed to find out where your case is at, did they get something that I filed? Justicecourts.maricopa.gov serves as a one-stop shop as well for the forms, guidance tools, as well as case status.
Great. That's a terrific resource. So check that out. I know there's lots of information. It's amazing how much information is on the court's websites and the state, and people just don't realize it. So I'll give you links to those as well in that article so that you can go directly to that. Really great information. You can get lost in that world. So let's talk about, in your court, you will come across actions that have to do with contract disputes.
Yes.
So what type of contract dispute cases do you most frequently see? Let's start there.
Okay. To answer that question, most frequently, debt collection. And that is somebody hasn't paid their credit card, whatever it might be, and then either the original creditor or assigned to somebody else or was purchased, somebody is pursuing collection of the outstanding balance on the credit card. That is the most common one we see. I will tell you as well, it's also the one that most commonly goes to judgment by default. Simply because, for whatever reason, folks just choose not to file an answer, and they've been advised that if they don't, a default judgment will likely be entered against them, and that is their call. But that's the most common filing we see in the civil division, and it's also, again, the one where most oftentimes somebody doesn't file an answer to contest it.
You also be a court that our property managers will see that their contracts be looked at for sometimes default, or is it deposit issues as well? What type of, for our property management agreements, what type of disputes would you see in that world?
I don't know, could you explain just a little bit more and maybe give me an example of what we'd be looking at?
Well, okay, so we have eviction, so we know you do
Sure.
eviction. So
Sure.
talk to us about that a little bit, and then we'll go through some other elements.
There are actually some new rules that I'll just use this as an opportunity that went into effect on January 1 of 2020 that affect eviction matters. Excuse me. And this is statewide, whether the eviction case is initiated in a justice court. Municipal courts don't have authority to handle an eviction matter. They don't handle civil matters, but for protective orders. Their jurisdiction is limited to criminal. But whether the eviction case is filed in a justice court in Arizona or it is filed in Superior Court, there are some new eviction rules that went into place in January 1 of this year. Not that you care, but I'll offer it. It's actually the Rules of Procedure for Eviction Action, Rule 5D is in Delta. Prior to it, it was necessary to demonstrate that the complaint, which is the basis for the lawsuit, the summons, which tells the defendant when to appear, and a document called the Residential Eviction Information Sheet that walks the defendant through why the lawsuit has been brought and what he or she can do. At the minimum, that had to be served upon the defendant if the case was going to go to judgment, perhaps by default at the time of the initial return. But with the change in rules, Rule 5D, there are some additional pieces of information that have to be served. I say served upon the individual, not necessarily filed with the court. That is an important distinction in my opinion. The rule is very clear. It requires some documents be served, but it doesn't mention anything about being filed with the court, and I'm of the opinion, because the rule is silent on this, these additional documents don't need to be filed with the court. But what has to be served in addition to everything else I mentioned is a copy of the pertinent section of the lease agreement that supports what's noted in the complaint. That is the cause of action, the reason why the case was brought to begin with. And in cases involving an allegation of non-payment of rent, then a copy of the ledger for the past 6 months, that is an accounting for the past 6 months. Those do have to now be served as well. That's one thing that I wanted to bring up as far as the evictions are concerned. I'm not sure what else would be of interest on evictions other than maybe to tell you this. It's a very short time period without muddying the water with a lot of time frames for you can only do this or that. And again, all of this information is on the Justice Court's website. It's a very short time frame from when the case is initiated to when the parties to the case are to make their initial appearance in a justice court. And then either the matter, it's patently evident that there is a basis for the lawsuit to have been brought and for judgment to be entered that day, whether the defendant does or doesn't appear. If they do appear, you'd ask them why. As a matter of fact, I had an eviction calendar this morning, and you routinely will ask individuals, have you paid this? No, I haven't. And why haven't you paid it? And the reason for that question, in my opinion, is to make sure that the reason for the non-payment doesn't constitute a legal basis for the non-payment under the Arizona Residential Landlord and Tenant Act. So you ask that question, and if there's no basis that is a defense that can be offered under the law, then it's going to be ripe for entry of judgment, and then you just simply go through the steps of telling them what they have to do when they have to return possession and things of that nature.
So when you're going through these contracts and you're trying to figure out who's doing what to whom and what's going on, what type of resources do you use? Do you access? You just mentioned the Arizona Landlord Tenant Act.
Sure.
What other resources do you use when you are looking over a contract and trying to figure things out?
I guess the best answer I can give in response to that would be it depends on the circumstances. And I know that's not very clear, but it really does. And by that I mean, let's suppose, I guess for argument's sake, a case is going to go to judgment by default. A civil lawsuit was filed, they want a certain sum of money, maybe there was a contract between the parties, and now they want a certain sum of money and the defendant hasn't filed an answer. Well, as the judge, you don't just sign on the dotted line, you don't just ask for the plaintiff to give you a proposed form of judgment and say, oh, that's good enough, I guess I'll put my name on it. There are some things you need to go through. For example, they need to provide a proof of debt. They need to substantiate the amount in writing that they're asking for. And if it was based upon a contract, they need to provide you with that section of the contract for you to be able to review. And if they don't, at least out of Arrowhead, they're going to get a corrective action notice from me telling me you didn't provide this, there's no basis for me to award you the amount you're requesting. So you've got, say, 30 days in which to correct this, and then we'll go from there. You need to look at the affidavit of service, make sure that indeed, in your opinion, from what's been filed, the defendant was indeed properly served with the summons and the complaint and the document called the notice to defendant, for example. And if it is, well, then you could probably go forward with the judgment. As on a default, you need to make sure that there is an affidavit under U.S. Code for the Service Members Civil Relief Act that the individual is not on active duty military, because you cannot sign a default judgment if the individual is, so you need to scrutinize that. I guess, and of course, and like I said, you do need to, even if it goes to default, you do need part of the contract to support. Judge, in the complaint, I asked for a $5,000 award because of a contract, and I'm of the opinion the defendant has breached it, okay? So just give me $5 grand. No, it doesn't work that way. You need to support that, and that's where the contract, if there was one, would come into play. Show me something, show me a ledger accounting as to when it actually went into a non-payment, when it was charged off, and that it supports the $5,000 reward if that's what's being requested.
Okay, so when you have people come into your courtroom, they usually are not familiar with the system or even how a courtroom works or the protocols. Can you tell us a little bit about how you conduct your courtroom so that the people appearing before you understand what's happening?
Sure. Admittedly, in this regard, what I'm going to focus on is the disposition of criminal charges, but it would apply to civil cases as well. The standard that I apply as far as, and the approach that I use applies regardless of the type of the case, but the illustration I admit I'm going to use is on a criminal charge. In a general sense, I use a very explanatory approach. My point of view is, put yourself in the shoes of that individual that is in front of you. And if you, as that individual, hadn't a clue what is going on, you just got your ticket that said you need to show up in court today, and if you don't, a warrant for your arrest could be issued. Okay, and if you don't make a habit of appearing in court, I get it. You don't really know what's going on. Now, at that point, there are some minimum requirements on a criminal arraignment hearing, which is the arraignment hearing is when a defendant first shows in court to have the judge read the charges to him or her, to ensure they're aware of the constitutional rights that they have at that time, to set release conditions, and to ensure compliance with victim rights provisions of the Constitution and the statutes if they apply to the charges. That, I would say, would be the bare minimum, if you will, that the judge could perform and then send the defendant perhaps on their way. My opinion is, as far as I'm concerned, it's not good enough. And by that, it goes back to what I said before about putting yourself in their shoes. And that is, as long as you don't give legal advice, which as a judge you're not allowed to do from the bench, and I also don't think you should recommend to a defendant, even as a nod, nod, wink, wink, if you will, do this, it'll work for you. That's not the judge's role. And at that point, I think that's inappropriate. And as long as you're not giving legal advice, you're not recommending that they take any particular action, there is no harm, and I think there's actually intrinsic value in a judge who is more familiar with this process than they are, explaining to them, here's what I had to tell you, now here's additionally what I'm going to tell you about what you can do. You can do this, and if you do this, then this is going to occur, and then if this occurs, then this will take place. And for me, the whole reason for doing this is to let the defendant make the informed decision as to what they want to do, as to where their case is going to go. They still have to make the call as to whether they want to do this or they want to do that. And it is true they haven't retained legal counsel to advise them on this. So I suppose you could say, well, that's your problem. You didn't hire an attorney, and if you don't know what's going on, that's too bad. I've met the minimum requirements. I'm done with it. I'll wash my hands of it. But that's not the approach that I think that works. And again, as long as you're just telling procedurally what they can do, I think they're better off for it, so they make that informed decision. And just as a quick follow-up on that, I will tell you, if ever I felt I needed verification that what I'm doing serves an actual purpose, I will tell you this. Even after all of this is explained, and it's time to call them to the bench for me to actually now read the charges to them and ascertain their plea, for them to enter it. I'll read the charge and I'll ask them, as an example, Mr. Wismer, are you entering a plea of guilty, not guilty, or no contest? Boom, like that, I get guilty. And I'm thinking, well, okay, it is your call. I'll tell you what, a clarifying remark, in my opinion, that has had real value is this then, is to tell Mr. Wismer as the example, Mr. Wismer, you were paying attention to when I said a lot, and it's an abundance of information. But you do understand, don't you, that if I accept this guilty plea, that it will result in a criminal conviction and criminal record. That could infect future or current employment, future or current professional licensing. Doesn't always work, but a lot of times that's when you see the proverbial light bulb go on for somebody, and they'll say, oh, can I enter a change of plea? Well, of course you can enter a change of plea, and you're entering a plea to not guilty. It'll be then set for a meeting called a pretrial conference, which I won't delve into. But the point I'm making is that whether it be in this criminal setting, it be on an eviction case where it's happening very quickly, or any other type of matter, if I'm conducting a pretrial conference in the civil division, I'm explaining to them we're now setting it for trial. Here are your deadlines. You need to disclose this information by this date, this information by this date, and is anybody bringing any audio visual to the trial? If you do, make sure you've done this or that. The reason is, my opinion is, it just facilitates moving the case along with everybody understanding, as long as they're listening to you, what's going on.
So I know when we had those interviews, we had a couple of our members who are property managers who had been in front of your court. And they said, we loved being in that court because it was educational for us as well as for the tenant. And you took the time to explain that whole process and the ramifications of those different decisions. And I know our property manager members really appreciated that and felt like that was a place where you could go and both sides could feel good about whatever happened out of that process. So
you just need to maintain your impartiality, and that's very important, is that you do, but you can maintain your impartiality while still explaining to folks who are there what their options are. Now, if they're represented by legal counsel, they're a professional in that regard. You don't need to explain to them. You may need to correct them if you don't agree with something that they're asserting, but you don't need to explain to them the processes and procedures. For self-represented plaintiffs and defendants, I think it's cut from a different bolt of cloth. Again, as long as you're not giving legal advice.
right, so that was a great benefit. I want to ask you, as long as we're on that, is it possible for members of the public to come in and watch proceedings in your court?
I am so glad that you opened that door because I want to walk through that, so thank you for doing that. Absolutely. You know, I make this pitch whenever I might be out at a meeting, and I understand coming into court to maybe see a civil bench trial or to see a criminal arraignment hearing or a criminal bench trial on, we'll say, assault or criminal speeding, for lack of a better term, may not necessarily be sexy. And so there's perhaps not a lot of motivation to actually come in and to see it. But you know what? It's a public courtroom, and if you have no professional or personal reason to be there, it is open to the public, and it can be educational, especially if the judge will take time once the proceeding is concluded, and I don't know who can't spare 5 minutes, to ask, ma'am, why are you in court? Well, I'm just here as an observer, Judge. Okay, thank you. Do you have any questions? Well, now that you asked it, sure. So-and-so objected to this. Why did you sustain that objection, or why did you overrule it? And as long as you're not really talking about the particulars of the case other than what they actually witnessed when things were going on, there's no harm, in my opinion, in telling them, well, I did because the rules allow this, or this wasn't permissible for this reason. It's an educational opportunity, and so I would invite any of you who are actually interested to come on out, whether it be to the Arrowhead Justice Court, or there are 3 other courts out of the building where I'm actually co-located, roughly Litchfield Park and Tierra Buena, which is where it's at. Come on out, and while I might have eviction cases going on, another court might have a criminal bench trial, another court might have a judgment debtor's exam going on, and who knows what. And you can get a lot of exposure to what goes on in the courts just by popping in and seeing what's going on in the fore. The only thing I would recommend is that if you're going to spend time going out, is call that clerk that court ahead of time and talk to a clerk to make sure that when you plan on going out at, say, 11 o'clock, that court actually has something going on. I mean, there are times when there is no calendar and you'd come out and you'd be the only one sitting in an empty courtroom. So I just encourage you to call them ahead of time and make sure there's something going on.
Great. So watch for that. That would be a great opportunity, and really educational and different. It's not like Perry Mason, which is what people's vision is.
Correct. It's not Perry Mason, and listen, it's not pick on somebody. It's not Judge Judy, okay? It's not Judge Brown. No, that's theatrics for entertainment value, okay? I don't know of any of my colleagues that let their courtroom run like what you see on TV in that regard. But it's also not necessarily like Law and Order. There are some elements to it, yes, but it's not a TV drama. It's real life that's going on. Maybe it's a bit mundane in a sense, but if ever you really did wonder, geez, beyond what I see on TV, what the heck really goes on in the courts? I wonder if I could set foot in one. Again, as I've said several times, absolutely.
So let me follow back up around and talk about the contracts that you see. One of the things that brokers are constantly reminding their agents, whether it's a sales agent or a property management agent, is to make sure the language is clear. But from your point of view, what type of parameters should we be using to figure out if it's clear? It may be clear to us, but it may not be clear to a third party looking at it. How do we go about maybe helping ourselves be more aware of the words we use in a contract, so it's clear to you, it's clear to the client, it's clear to everybody?
That's a good question. I'm not sure what pearl of wisdom I could really offer that would actually help you focus on do this and do that, and it will then be more clear. I mean, one thing that does come to mind is, think of it this way. You're more familiar with your contracts and your case than I am until you present it to me. And as a matter of fact, you'll still be more familiar with the ins and outs of your contract until perhaps you need to present it to me, let's say if the case goes to trial, and then that's your job to educate me on what are the components of it if it does go to trial, and then I, as the independent third party, will take what you give me, will take what the defendant gives me, and then I'll render my decision. But back to the question, perhaps the only thing that comes to mind right off the cuff would be this, and that is turn it over to somebody that knows nothing about what you do for a living, and see if it is patently clear to them what are some of the do's and don'ts. What are the deadline for doing this, and if you do this, what are the benefits? If you don't do this, what are the repercussions? I guess it might be a starting point.
Okay. I will just tell you, make sure you're visiting back with your brokers to make sure whatever language between the blank lines that you put so that it is clear. So if Judge Wismer or a third party or your clients ever have to read it, they know it is. One of my pet peeves when I was a broker was to get these contracts and say 3% buyer's closing cost. Well, what the heck? Who did what to who? What is that? That's just a phrase.
And you know, just as another example of one that comes to mind, and it's just again to simply illustrate something, I think in one of the contracts that I can think of, it might have said that late fees accrued at the rate of $100. But it didn't say per day, per month, a flat fee. Now you've left that open to judicial interpretation based upon what I hear from you and what I hear from a defendant, if a defendant is actually there. So again, it just perhaps goes to the same point of some clarity, making sure the I's are dotted and the T's are crossed.
It's very important. So thank you. So you hear cases having to do with minors as well as the other types of cases. Can you tell us your approach to these cases? What type of cases do you have and what's your approach?
Sure. I do serve as a juvenile hearing officer, and while I do see a number of juvenile defendants on civil traffic charges, like we can all be cited with speeding and broken windshield or whatnot, most of my job as a hearing officer involves the disposition of criminal charges that have been brought against them. The most commonly cited criminal charges in the Arrowhead Justice Court for individuals who are under the age of 18, it's not limited to this. Again, the most common are criminal speeding, aggressive driving, reckless driving, and even more commonly, curfew violation for a violation of the City of Peoria Municipal Code as far as that's concerned. It could involve Maricopa County's code on that, but I don't think I've ever seen one cited into the court. Also, minor possessing or consuming alcohol, and then the big one is minor possessing a tobacco product or a vaping device. And a couple of things about these charges. They're to appear for a juvenile advisory hearing. It's not an arraignment hearing. That's for adults. This is called a juvenile advisory hearing. I still read the charges to them. I ascertain their plea, but their plea isn't guilty or not guilty or no contest. It's responsible or not responsible. When the, excuse me, when the charge is filed with the Arrowhead Justice Court, if under law as a juvenile hearing officer, first off, I have the authority to even adjudicate it. And there are certain charges as a hearing officer the law does not let me as a hearing officer handle. I can't handle most Title 13 offenses, but for the vaping and tobacco. For those of you that aren't familiar with this, and that's a good thing as to what Title 13 involves, some examples are shoplifting, assault, threatening and intimidating, trespassing and whatnot. Juvenile hearing officers cannot hear those out in the field. Those have got to go down to juvenile court. But other than that, when they're filed with the Arrowhead Justice Court, if the prosecuting authority, who is the Maricopa County Attorney's Office, says, yes, we will leave these in the hands of the juvenile hearing officer, then the juveniles are going to be making their appearance in front of me for that advisory hearing. A couple of things I don't do. If in an adult court an individual retains legal counsel to represent them, the rules do allow for the attorney to represent them and make the appearance without the defendant until the defendant's presence is absolutely necessary. I could waive the juvenile's appearance. I could waive the parent's appearance for the advisory hearing if I wanted to and I thought there was good cause. I can tell you across the board I don't, even if they have retained legal counsel. A couple of reasons. One, the juvenile cases are cut from a different bolt of cloth. I know a lot of folks are not familiar with them. When I see pleadings come in from the attorneys, to their defense, they're not aware that they have already been allowed to go forward as a juvenile case. They might enter a plea of not guilty on behalf of the defendant. That's not a proper plea. They might ask that the court vacate the arraignment hearing. That's the adults, that's not the kids. They might ask then that the court set the case for a pretrial conference. It's not a pretrial conference, it's called a non-witness hearing. The point is, even times legal counsel doesn't know that it's going through a juvenile process. So I'm not content just letting the attorney show up to convey the message to mom and dad and to the kiddo as to what this court imposed in the way of a consequence if the attorney entered a plea of responsible on behalf of the kid. The son or daughter, as well as the parent or legal guardian, is going to have to make their appearance in court. So they understand what are the charges that have been brought against them. Mom and dad knows what the deadlines are for their son or daughter to comply with court orders. The child knows, the parent knows what are the consequences if they don't comply. That way they're fully informed. So they've got to come in.
Okay, great. And then I wanted to ask you about, you preside over the Maricopa County Regional Homeless Court. And as fate would have it, we just had a little bit of conversation before you came about the homeless issues in the cities. And the question was, what can cities do? And we talked about some of the federal court, the Ninth Circuit decisions out of Boise and that type of thing. So can you tell us more about that court, what it does, and does that Boise case impact any of what you do?
First, to the Boise case, I am familiar with it. It had been the Ninth Circuit Court, I think it was a 3-judge panel. It went through the process. They asked for a rehearing en banc. That was denied. They asked for the Supreme Court recently, U.S. Supreme Court, to take this matter. They declined. So the Ninth Circuit Court of Appeals is binding, and it remains in effect. It's authoritative as far as their jurisdiction is concerned. The 9 Western states, it has influence on a national level. Mm-hmm. But yes, it is. I don't think the issue of that case is really going to have much impact on the justice courts, and I'll tell you why in a moment. Yes, I do serve. Last year, I was appointed as a Justice of the Peace representative to the Maricopa County Regional Homeless Court Governing Council, in which we will set policy on how cases will be handled for individuals that are documented. It's been demonstrated they are homeless. It's not speculative, it is known. The way the process briefly works is that for an individual that has an outstanding, this could be handled pre-adjudication or it could be handled post. Most of the time it's handled post-adjudication. If an individual has an outstanding civil traffic balance to a court, be it a municipal court in the valley or one of the justice courts in the valley, or they have an outstanding criminal fine, we're not talking restitution. Restitution cannot go through the homeless court process. But something other than that, once the individual connects with a homeless provider, as an example, Central Arizona Shelter Services or UMOM, just to name a couple of them, once their representative there becomes aware that they've got some outstanding issues with the courts, they will get in contact oftentimes with the Maricopa County Regional Homeless Court and ask for them to reach out to the trial court to ask if the trial court would be willing to allow this case to be then concluded through the homeless court process. And if the trial court says, yes, indeed, that you have my permission to do that, the consequence will be actually performing community service at the rate of $10 per hour to resolve the criminal fine that's outstanding. That could also actually be done for civil traffic balances that are outstanding. In that regard, as far as civil traffic balances that are outstanding, I routinely will actually refer cases down to the homeless court, and if the matters aren't wrapped up timely, they get remanded back to us and we retain jurisdiction to handle the matters until it is fully resolved. Civil traffic, I will just tell you my persuasion on these and what I do. If the individual has civil traffic balances outstanding to Arrowhead, we already know that they are homeless. Again, there's no speculation, no guesswork. I don't have to trust anybody other than the provider says they are indeed homeless. Then if the request comes from the Regional Homeless Court folks to the Arrowhead Justice Court asking if I'll transfer it down there for the disposition of the civil traffic balances by them performing community service, on the civil traffic I won't transfer it, I just suspend the balance that's due. Criminal is a different issue. They need to do some community service to resolve that. Civil traffic, they are important issues that need to be addressed and they have a balance outstanding to the court. But for those, I have the authority to suspend the balance if I want to, and that's indeed what I do. I'm of the opinion for civil traffic balances in that scenario, go on, get on with your life. Hopefully you can, with the help of some folks, find a way to actually get out of this issue of homelessness, get a roof over your head, and not worry about, in that case, just a money balance that's owed to a court on a civil traffic issue.
Okay, great. And then I also want to remind the panel folks, if you guys have questions, you can send it through in the chat box. In July 2019, you were appointed by the Chief Justice of the Arizona Supreme Court to be a member of the Arizona Judicial Ethics Advisory Committee. Tell us what that committee is and what it does.
Sure. That is correct. At the time, the Chief Justice of the Arizona Supreme Court was Scott Bales. The Arizona Judicial Ethics Advisory Committee is comprised of judicial officers, a number of them, some from Superior Court, Municipal Court, the Arizona Court of Appeals, And there is one Justice of the Peace representative, a slot, if you will, that is available for membership on the council, or on the committee, rather. And I did make my application, and Chief Justice Bales did appoint me to serve in that capacity. So I serve as the Justice of the Peace representative on the Judicial Ethics Advisory Committee. There's an important distinction to make on this. There's a Judicial Ethics Advisory Committee, and there's an Arizona Judicial Ethics Commission. The commission, they take cases where there is an allegation of noncompliance or misconduct by a judicial officer with the Arizona Code of Judicial Conduct. We call them the judicial canons, but it's that somebody has lodged a complaint and said this officer this judge has done this, it violates the judicial canons, we want you to investigate it. They have a process they go through. It, as to kind of circular here, it's what led to the previous judge being removed from the Arrowhead Justice Court. The Judicial Ethics Advisory Committee, on which I serve, I would call it, we're proactive. We issue advisory opinions based upon requests that come into the committee for input that is very scenario-based. And that might be, judges, if I wanted to do this and I did this, would the judicial code let me do it? And the executive director, either if the individual wants just an informal opinion, she may be able to render that formal opinion and give something back to the individual that made the request. If she feels that it's of value, she can ping the members of the committee, paint the picture for us based upon what came in. We will give our input as to whether it runs afoul of the code or not and why we say that. If the individual requests a formal opinion, that's when it actually gets put into writing. It is on the commission's website for the public to see, the judicial officers to see, that will let them know you can do this, you can't do this, and here's why the code does or doesn't let you do that.
Okay, great. And we find that on which website? I'm sorry, I was writing down notes.
Pardon me?
Which website would I find that on? I'm sorry.
That one I'd have to actually break out Google.
Okay.
It's the Arizona,
the
Arizona Commission on Judicial Conduct, or the Arizona Judicial Ethics Commission, rather.
Okay.
You do that search, and that'll bring you up with a list of public decisions, ethics advisory opinions from the committee, and opinions from the Ethics Commission.
Okay, great. We'll look into that too as well. So it sounds like you basically are almost a input and brainstorming group in that committee. We have something, and we're all giving. So how do you end up once everyone's given their opinions and brainstormed? What's the process to actually get to that? How do you determine? Do you have a debate between yourselves? Is it in person? Is it like over a Zoom? Or how do you guys? What's the process? The physical process you guys go through to figure that out?
If it actually gets to the point where there's a reason to issue a formal ethics advisory opinion, then the executive director will be setting the stage for that and will actually let the membership know there's a reason why a formal opinion is necessary. In my opinion, informal won't do it. Or the person asks for a formal opinion and now we've got to get everybody's input and put it in writing. It's using modern technology in the sense that it's just a back and forth by exchange of emails. Okay. You just do a reply all, that becomes the conversation amongst your colleagues, and it may then blossom into something even bigger. Then the executive director will take all the input, distill it into a draft report, circulate it back to the members. If everybody essentially blesses it, that's when it's going to go to print.
Okay, so make sure what your input was actually is what came out on the end. Correct. Backside. Okay, great. Correct. So you're Justice of the Peace. What is your favorite part about that job?
Well, my favorite part about the job is not putting people in jail. I mean, I don't deny sometimes you're required to do that. There are statutory minimum sentencing provisions. And even if there aren't, sometimes it becomes readily apparent at the sentencing hearing that the defendant who was convicted, their behavior is so out of line and there's absolutely no remorse, and due to the rest of the circumstances, the totality of it, a period of incarceration could be appropriate, and yes, I have done that when I felt it was necessary, as long as I had an opportunity to be heard. But that's really not what is my favorite. To really answer your point, what is my favorite on this? And that is, believe it or not, it is the opportunity to explain to folks. I know it sounds educational, it sounds maybe like the profession of a teacher, I get it. But it really is the opportunity to have that dialogue, as long as they're willing to listen. If they're not willing to listen, we'll cut it short and you'll be on your way. We'll do what we have to do and then off you go. But as long as they're willing to listen to what the judge has to say, what I have to say, to explain to them, again, yes, you can do this, no, you can't do this, if this happens, this is what will occur. That's the favorite part of my job, believe it or not. And again, it goes back to, I say it in all sincerity, putting yourself in the shoes. It's much like here. We have a dais and you've got the floor, only my bench is a little bit taller. But again, you've got somebody down there that truly, it's obvious they have no idea what's going on. An opportunity to educate them still while they are the ones that, because they have to, making the decision about where things are going to go. You know, I will tell you, and it's not that you asked for a justification for why you find that the most interesting part of your job, but I'll offer something anyway. What I did as far as my professional employment with Congressman and Senator Kyle was on an issue specialist on a number of issues. It could have been on immigration, veterans issues, Section 8 housing, things like that. Routinely, it happened then, it happens nowadays, people will call their member of Congress and say, listen, I'm having a problem with the XYZ federal agency, I can't get this or I can't get that, or they won't tell me if I can do this or that. And then if you take on that role of somebody that will actually go out and take a look at the relevant laws, the field manuals and whatnot, to then be able to digest this, get input from the agency as well, digest this, and then go back and explain to them, here's what they said. If you do this, you can do this because the federal law allows it, and here's the U.S. code. Or if you did do it with this within this time period, here's why, and look at the Code of Federal Regulations. This, to me, is an extension. Only what I'm telling them is what the laws have to say, what the rules of criminal procedure have to say, what the rules of procedure for eviction action have to say, and what are your time limits and so forth.
So we have a few more minutes. Does anybody, you guys are really quiet this time. Does anyone have any quick question they want to ask Judge? Go ahead.
It's just my personal experience with my my landlord. She had a rental, and we went with her not as an attorney or anything, but because she's Vietnamese and she does speak English, we went with her, and I felt that they're not a judge, whatever they are in small claims court, because they're not judges like you. Right?
A caveat. A justice of the peace can hear a small claims matter either because he or she wants to, or because somebody does not want a hearing officer hearing the case, they can ask that it be transferred to a justice of the peace. But you are correct, yes, they can. And there are times when it's happened, and then I'll take the case and I'll preside over that hearing. But you are correct, it's oftentimes a small claims hearing officer that would preside over that small claims hearing.
Okay, so we were there as more of a support to her, and she had all the documents in front of her, but the thing is, she was so nervous. And the person, I don't know what you want to call them, but the person at the front wasn't like you, wanting, you know, her to express herself and get help. Because she had to actually physically ask him the question, but she didn't know what question to ask my husband, who was trying to help her. And I felt that he wasn't really helping the landlord, you know, probably thinking that she was in the wrong. So I'm just saying that you can ask for somebody other than, I don't want to say a non-judge, but you know what I'm saying, I don't think they're judges when they're in small claims normally.
Oftentimes not, you're correct, they are an appointed civil or small claims or civil traffic hearing officer. Civil traffic hearings, I actually, as a justice of the peace, I preside over my monthly docket of civil traffic hearings. I like to do that, even though oftentimes courts use civil traffic hearing officers, and there's nothing wrong with that. To answer your question, yes, somebody can request that if the case is assigned to a hearing in the small claims division before a hearing officer, they don't, for whatever reason, want it heard by a hearing officer, they can ask that it be transferred to the justice of the peace to be heard. You still have no appellate rights, though, even if it's heard by a justice of the peace in the small claims. That's one of the caveats. Then you are bound by the decision of the hearing office or of the justice of the peace who conducted the hearing, and you can't appeal his or her decision.
I just think that if she could have conversed with the person that was helping her, I mean, not as an attorney capacity, I think it would have been more clear, because he kept asking her, but she couldn't say anything to anybody else. She had to ask the question.
You know, in the small claims division, I don't deny when it goes to a hearing, There is a formal structure that I think needs to be observed as far as you present your case. Do you have any questions to cross-examine? Any witnesses you're calling, cross-examine. Now present your case, defendant. Plaintiff, you can cross-examine. You need to preserve that structure, which is pretty common with a bench trial in the civil division as well. That being said, small claims, because attorneys are not allowed to be used unless the parties stipulated a use of attorneys, and I've never seen that occur. Once that occurs, they ask for it to go to the civil division. The small claims hearing officers or justices of the peace have to do a lot of work at the time of the hearing, trying to bring out what is necessary to make a decision. So there's usually a lot of a colloquy back and forth. Well, did you do this? Did you do that? Do you have anything to support that? Because folks don't know to offer it.
And I don't think he did that, and that's what I think that was the missing piece, but if you can ask the judge, I'll just tell my clients just to skip. Sorry.
So going back to the evictions and, did you pay the rent? No, I did not. Why? So I love that you asked why. What if the defendant were to say, well, the sewer backed up into the house and it put sewage all over the floors and the landlord had a crew come in and vacuum it all up and clean the carpet, but it still smells like a sewer inside my house and they need to replace the flooring, so I haven't paid my rent. So what would happen in like that scenario?
I would say across the board, regardless of the scenario, again, the reason for the question is to make sure that the reason for the non-payment, because a lot of times you'll have defendants in front of you, did you pay it? Nope. Well, if you wanted to stop there, you could. But you, in my opinion, you really need to establish that the reason for the non-payment does not constitute a legal defense under the Arizona Residential Landlord and Tenant Act. So you would have to ask the question then, well, why didn't you? And if they were to say financial hardship or something that doesn't constitute a legal defense, then you know that judgment could be entered right then and there. If it turns out that you know for a fact what you hear constitutes a legal defense, or it could constitute a legal defense, but it may not become patently evident until evidence is presented, you don't take evidence at the initial appearance. Nobody's placed under oath for sworn testimony. It's just a quick, why'd you bring the lawsuit? Did you do this? What are your defenses? If that's what you're going to present at trial, there's no reason for me to set this over for trial. Judgment's entered, and you can talk to them about some options that I go through with them, as well as far as still talking to the plaintiff if they want to resolve it to still have you stay, or if they're willing to ask for an extension of a writ of restitution, they can do that as well. But if it becomes evident, I don't know what your defense is, or this could constitute a legal defense, then you set it for trial. And in the justice courts, by statute, you are given 3 judicial days from the date that they appear to be able to set it. So you could set it the same day if you have time on your calendar, the next day, the day after, but no longer than 3 judicial days going forward for trial, unless the parties stipulate to an extension of time. If they both agree, we'll set it 7 days from today's date, and the court calendar would allow it, well, now you could do that. But other than that, you're bound by what the statute said, which is 3 days.
Oh my gosh. Okay, everyone. All right. John, go ahead.
What constitutes a legal defense for the tenant?
There are, well, it's that there were some minor defects, there were some minor repairs. You did actually give written notice to them of some minor defects, and then you decided to take it upon yourself to actually hire somebody to do the work. You'd have to have some documentation to support that as well. That's on just typically the issue of non-payment. There are other bases that can be cited for bringing an eviction case. It doesn't have to just be an allegation of non-payment of rent. It could be a material and reparable breach of the lease agreement, such as the lease agreement said 2 occupants, but they're alleging you have 5.
Right.
Well, you'd have to be given an opportunity with a 10-day notice to cure that. If you do cure it, it doesn't go to a lawsuit. If you do cure it, but it occurs again, they could still then bring it as a lawsuit. And then there's material and irreparable breach of the lease agreement, and there's a certain section statute under Title 33 that talks about some criminal offenses, although it's not an exhaustive list, that would constitute a material and irreparable breach of the lease agreement. In other words, you've done something that there's no opportunity to cure.
I don't know if you can answer this or not, but I've gotten into several disagreements with people that what's left of them, these speed cameras. if you are sent a speeding ticket because you were going too fast, I've been told two things. One, drop it in the shredder because they have to present it to you to make it a legal document. And two, just ignore it. What is the actual rule of speeding?
Well, I'm only going to wade into that pool a bit. And I say that for a reason. First of all, in my jurisdiction, the cameras are no longer on Loop 101. I know at one point in time there was an argument about it being being unconstitutional. Some folks took that position, but that's even from quite a long time ago. The only thing I would point out with this would be this, the practical issue. If you were at the roadside and you actually were presented with an Arizona traffic ticket and complaint, you signed it promising to appear on the date and time that's on there and you don't, page 2 tells you clearly what's going to happen. And a default judgment is going to be entered against you for the disposition of the civil traffic charges. Your license to drive will be suspended. You'll owe money to the court. That's if you sign for it. Here we're talking about you go by, it flashes you, and you admit that you get notice, but you choose not to appear. The best answer I can give you is, it's my understanding you run the risk of a default judgment being entered against you. The practicalities, though, I'm really not going to step in on because I'll confess I don't know much about how the courts handle it because it's never, they've not, since I took the bench in 2012, the traffic cameras on the 101, the speed cameras have not been operational. So I'll confess I don't know much of the behind-the-scene do's and don'ts about what's being done as far as service of process.
One of the reasons I'm asking that is a friend of mine had that happen, and she went to Department of Motor Vehicle, and she pulled her motor vehicle record, and there was she had had 2 speeding tickets with the camera, and it was not on her record at all.
Okay, well, you know, it's certainly possible that when it gets filed with the court, the court could dismiss it if they felt there was a reason to do it. I don't know if that's what they did, and I don't know what would be their policy for a dismissal unless it becomes apparent that the person perhaps wasn't served with it. I don't know.
Okay, last question, go ahead.
You were saying that you have certain days to set the trial. For your initial hearings, if you have specific days, let's say Tuesdays are for evictions, Wednesdays are for this.
Correct. Right. And you are correct. Just on evictions, that issue itself, the eviction calendar in the Arrowhead Justice Court is every Tuesday and Thursday. I have a criminal calendar on Mondays, a criminal calendar on Wednesdays, Thursdays, civil calendar, Tuesdays are civil calendars as well, plus arraignment hearings, juvenile advisory hearings. Yes, in this court, there are set schedules for when types of cases are filed and when they're heard.
Great.
And I know we're pressed on time, and I know probably everybody else has to get back to business, but if it's no problem, I'm fortunate to have somebody that's able to, well, let me just say I'm fortunate to have a little bit of time today that if you'd like, I can stick around for a little bit and talk individually if you have any other questions we
nice.
just weren't able to get to here in the presentation.
Oh, that's so nice of you. Thank you so much. We so appreciate your time.
If I may, before
Yes.
Liz, you'd say anything you wanted to wrap up, again, let me just extend that invitation since it was brought up before. Be it the Arrowhead Justice Court or the other 3 in my building, if you just have this nagging curiosity you can't get rid of as far as what happens in court, pick up the phone, call the clerk ahead of time and say, listen, I'd like to be there at Thursday, maybe around 1 o'clock. Is anything happening? And if they say, sure, well, ask them, is it likely going to be busy? I would tell you in the Arrowhead Justice Court, I can almost guarantee you, you're going to see something happening on a Wednesday morning. It's for all the pretrial conferences on criminal cases. You wouldn't even have to call, but do it ahead of time anyway. You wanted to see Monday morning is pretty busy on those as well. But again, point is just call and ask, if I show up on this date at this time, does your calendar show you usually have a lot of stuff going on, so I got something to watch? And if they tell you yes, come on out. If you find out it's a bit of a bust in that court for some reason, you got 3 other choices you can make while you're out there and find something going on. And then ask the judge if you want to, once everything's wrapped up, raise your hand, just ask, can you spare a couple of minutes to answer a question about what just went on? I'm here as an observer. I'll certainly entertain it, and I would think others would as well.
Wonderful. Thank you so much for your time. We really appreciate it. This
Well,
has been great.
Well, thank you for the invitation.